and welcome everyone. Thank you very much for joining us today. I'm Justice Catherine Feldman, of the Ontario Court of Appeal. Today's webinar is called Good Judgment, and it is part of the Jackman series. Before we get the program underway, we wish to acknowledge that the land on which the University of Toronto operates has for thousands of years been the traditional land of the Huron-Wendat, the Seneca, and the Mississaugas of the Credit. Today, this meeting place is still the home to many Indigenous people from across Turtle Island, and we are grateful to have the opportunity to work on this land. For today's sessions, my fellow graduates, Justice Robert Sharpe and Guy Pratte, will be delving into the topic of judicial decision-making. What makes a judicial decision a good judgment, and is there always a right answer? I'll just tell you, give you a bit of an introduction to these two distinguished panelists. Justice Sharpe is a distinguished Canadian lawyer, author, academic, and judge. He served as a judge on the Court of Appeal for Ontario from 1999 to 2020 and is currently the Distinguished Jurist-in-Residence at the University of Toronto Faculty of Law, as well as a member of Arbitration Place. His impressive career includes roles as a professor, dean, and legal officer for Chief Justice Dickson of the Supreme Court of Canada. He has received a number of prestigious awards and honors, including the Order of Canada, and has authored several influential books, including Good Judgment, Making Judicial Decisions, which he wrote in 2018. Guy Pratte is an award-winning lawyer with experience in complex commercial litigation, including class actions, administrative law, and constitutional law cases. He has served as the president of the Advocate Society and the chair of the Cambridge Lectures. He frequently appears before the Supreme Court of Canada, the Superior and Appeal Courts of Ontario and Quebec, the Federal Court, and the Federal Court of Appeal. He was named to the Order of Canada in 2022, recognizing his many contributions as a lawyer, including pro bono work, and for his volunteer commitments to the performing arts. He is currently the chair of the National Arts Centre in Ottawa. So I just want to tell you a bit about the format. The two panelists will be speaking for about half an hour, the first half of the program. And then after that, we're going to open it up to a question and answer session. So please submit your questions anytime using the Q&A function on the bottom of the Zoom screen, and I will try to pose as many of the questions as time allows at the end. So, Justice Sharpe, please begin the discussion.
Thank you very much. So the question is, what is a good judgment? I discovered during my 25 years as a judge, and when I was trying to write my book, Good Judgment, Making Judicial Decisions, that the answer to that question is a little more complicated than it might seem. The law does not always point judges unambiguously in the direction of the so-called right answer. That means that judges must make difficult choices, often with only general guidance from the formal legal rules. This element of uncertainty may seem at first blush to be a flaw in the legal regime, but the more I thought about it, the more I became convinced that it was an inevitable and in fact desirable feature of law. Inevitable because laws must apply generally to all, and that means that the law will necessarily be general in nature. Generality is what gives law its objective, rational, and systemic quality. That is what distinguishes the law from the judicial decisions applying the law. It is simply not possible to craft laws that achieve universality of application and at the same time provide immediate answers to all cases that might arise. The immediate answers applying the general legal norms in particular cases are provided by courts and judges. It's desirable because it gives judges the flexibility to make just decisions tailored to the facts of each case. Now, I think it's important that judges be honest both with themselves and with the public they serve, and not pretend that the law always yields immediate and obvious answers. When deciding cases, we do not just call balls and strikes, as Chief Justice Roberts famously claimed during his confirmation hearing. I believe that conscientious judges should not hide behind a facade of judicial neutrality, but rather that they should engage in the self-reflection necessary to ensure that their personal views and attitudes are placed in proper perspective. As a judge, I welcome the fact that the law was sufficiently flexible to allow me and my colleagues to decide cases justly. But how far could I go? Did I not have to constrain my judicial choice and judicial discretion to remain faithful to my oath to uphold the law? I certainly did not feel that my choices were unlimited or that I could decide cases according to my own personal sense of right and wrong. I had to come up with a decision that respected my obligation to follow the law. The judicial choice I exercised to reach just results had to be reconciled with the judicial discipline required to maintain the rule of law. My job was to do justice, but the justice I rendered had to be justice under the law, not justice according to Bob Sharpe. The importance of reconciling judicial choice with judicial discipline has become more evident in recent years, particularly in the era of the Charter of Rights and Freedoms. When I started my legal journey as a law student a very long time ago, a legalistic version of formalism reigned. Judges were discouraged, if not forbidden, from considering the normative underpinnings of the laws they interpreted and applied. There was very little consideration of the broader social context from which the case arose. Courts rigidly followed precedents, even if the precedent was old and out of keeping with contemporary circumstances. By the time I became a judge, the era that Brian Dixon had described as blind and empty formalism was history. The pretense that cases could be decided by mechanical application of clear rules, just calling balls and strikes, had been abandoned. I welcomed this liberation of the law from its rigid past. It presents a more accurate picture of the law and judicial decision-makings, and it gives judges the liberty to decide cases justly. But when I became a judge, faced with the responsibility of deciding cases, I started to worry about the element of uncertainty in the law, that the element of uncertainty in the law posed a danger. Could the greater liberty to decide cases that this modern view of law presented disintegrate into unconstrained liberty to decide according to the judge's personal sense of right and wrong? And if so, where would that leave the rule of law? When I wrote Good Judgment, I wanted to see if I could describe what I instinctively felt as a judge, namely that there must be an acceptable middle ground between the pretense of blind legal formalism and the risk that recognizing judicial choice and discretion allows or encourages judges to decide on the basis of their personal views of right and wrong. This is what Australian Justice Michael Kirby described as somewhere between the spectacle of the judge pursuing political ideas of his or her own and the unrealistic mechanic deified by the strict formalists. I had to recognize that the law did not always provide me with clear answers. These are what lawyers and judges call hard cases, for which there will be legitimate and likely unresolvable debate about what is the right answer. But when I was faced with a hard case, I did not think I could say, the law is unclear, so I can just do what I please here. I can decide this case however I want. In a hard case, I had to accept there was room for debate. My answer was not legally inevitable, and another judge might decide the case differently. But I did my best to persuade my colleagues, the litigants, and the public at large that I had reached the right answer. I did not think that the fact that there was no way to be sure that I had reached the right answer relieved me of the duty to aspire to achieve that goal. I had to work with existing legal sources, however imperfect or incomplete, and I had to try to decide the case in a legally principled way. I thought long and hard about each case. I read as much as I could about the issue it presented, and I did my best to decide the case in a way that fit the existing legal sources and made the law a more coherent whole. I tried to follow what has been called a cardinal judicial virtue, namely to deploy some recognized or accepted principle as a reasoned basis for my decision. In Good Judgment, I described the factors that discipline judicial decision-making. In particular, the obligation to support every judicial decision with a reasoned explanation. There is nothing like the experience of sitting down to write reasons for judgment. Those reasons will be read by the parties, they'll be read by the lawyers, the professors, the public, other judges, maybe the Court of Appeal, maybe the Supreme Court of Canada. Believe me, that focuses the judicial mind. I found that often my first impression about how a case should be decided did not survive the scrutiny of the judgment writing exercise. As a member of the legal community that aspires to uphold the rule of law, and as one who had taken an oath to uphold the rule of law, the judgment writing exercise reinforced my duty to give priority to the law over my personal beliefs. I've said that blind and empty formalism is dead, but there is an important element of formalism that remains. And it is this: judges are expected to base their decisions on accepted or recognized legal sources. The law, however incomplete or imprecise, sets the parameters for judicial decisions. My role as a judge was different from that of a scientist, a philosopher, a social scientist, or a law professor. They are engaged in unconstrained search for the truth. I was doing my best to come up with just results within the law and within the limits the law imposed. They were expected to arrive at the best result, all things considered. I was not allowed to consider all things. Now, of course, judges aspire to reach just decisions. And as Israeli Justice Eran Barak has argued, if the law seems to point them in the wrong direction, then they should carefully retrace their steps to make sure that they have not strayed from the law's path, as the law's aspiration is to do justice. Now, I'm sure that for some, the views I expressed in good judgment will seem too liberal. I reject the I just call balls and strike approach to judging. I recognize that judicial decisions could be influenced by a judge's beliefs and background, and I accept that there is a legitimate lawmaking role for judges in the common law tradition. I welcome the role conferred on judges by the Charter to advance our fundamental rights and freedoms. On the other hand, some might think that I'm taking an unduly conservative view of the judicial role by insisting that disciplined judicial decision-making limits the capacity of a judge to make the world a better place, and at times requires judges to make decisions they'd rather not make. My middle ground probably will not please or convince anyone, as I expect you're about to hear from my good friend, Guy Pratte.
You're muted. There you go.
Yeah, I think Bob did that on purpose. I need to start by saying that I've been asked here to be the agent provocateur in this event, because I'm asked to argue that judges don't really follow the law. They just, as we say in the vernacular, make it up as they go along. And I'm asked to do that in an intimidating setting because I'm not a judge. I don't have the experience that either Justices Sharpe or Feldman have. And I'm debating one of the most celebrated judges in Canada in front of another outstanding judge as moderator, Justice Feldman. But I accepted this challenge because barristers from time to time are supposed to do advocacy that's courageous and argue unpopular causes. Although I have to say that I hope I won't suffer the fate of old John Cook, who was persuaded to defend Charles I on his trial for treason and ended up himself being drawn and quartered for his courageous advocacy. So let me start by summarizing what I understand Justice Sharpe's basic thesis is, as he's outlined it now, but also in his book. I think it's really based on three claims or propositions. The first one is that judges' fundamental job is to decide every case justly, a word that he's repeated and used repeatedly today. Suggesting that justice is not always the same as the law itself. Second, and that comes out maybe more clearly in his book, that the uncertainty in the law is really exaggerated and that the vast majority of legal disputes can be decided based on appropriate legal principles. And the third proposition is that, as he just said, there are a few uncertain hard cases that are maybe open to debate, but that if you reason hard enough and look at the appropriate legal sources and expose your reasoning to scrutiny, then ultimately you might reach the right answer or the just answer. So let me start with proposition one and making a few comments on that, because in my respectful submission, once you understand the distinction between justice and law, you necessarily and inexorably move to the conclusion that Justice Sharpe is wrong in proposition two, that most cases can be decided in accordance to law, and three, that even in hard cases, there is a right answer. So the question that is posed by his claim that the judge's job is to decide each case justly it begs the question is, well, is justice not exactly synonymous with law? Apparently not. And I agree with that, because when you think about it, the laws are the result, effectively, of the social consensus as expressed by Parliament of what justice should require. In other words, justice informs what our law should be, but is distinct from it. Justice stands as a concept as distinct from the laws per se. The second point about justice that is worthwhile remember, particularly in this discussion, is that justice is not some objective norm, mathematical norm. It's a highly subjective, individualized concept. It's something each of us, even non-lawyers, develop as we go through life, sometimes adopting some values, honing them, changing them. But always we have a sense of what justice requires. And oftentimes it doesn't coincide with what the law might be. And certainly when the law is uncertain, then we, as I'll try to argue, have to resort to that sense of justice. So now let me move to proposition number two, which is the proposition that is argued in Justice Sharpe's book, that the extent of uncertainty embedded in the law is quite limited, as it were. I say, in fact, that the uncertainty embedded in the law, in the legal system, is vast and comprehensive. And in a way, it's what I'll call intentional uncertainty, because our legal system adopts some very general standards for the reasons that Justice Sharpe has alluded to. Let's call, as an example, the reasonable person standard we apply in tort law, for example, among other places, which as a standard, when you think of it as a normative standard, really doesn't tell anything to a judge, or very little. Once you pronounce the words reasonable in any particular set of facts, you'll have a huge array of choices to make. And that choice, in my respectful submission, is essentially unconstrained and allows judges effectively to shape their findings of fact, or even what the law requires in a particular way. So let's look at three situations where necessarily a judge's personal view of what justice requires, of what the just result is, three situations where judges have immense discretion. On pure questions of fact, we know that the standard of appellate review is the extraordinarily difficult standard of a palpable and overriding error, which is also a somewhat elastic standard. Anyone who has actually looked at the case law applying it will find that it's full of inconsistencies. But it certainly is a high standard. What does that mean? It means that in practice, trial judges can shape the evidence and their findings of law in ways that are often unreviewable. And it's not a criticism. There's no other way to decide whether or not the facts on a balance of probabilities, another extraordinarily elastic standard, can be met or determined to be met on the facts. One judge will find facts one way on the same evidence, and another will find them another way. In fact, if you read the jurisprudence on the overriding or the palpable and overriding error standard, you will see that often courts of appeal will say they might, on the same evidence, have made a different conclusion of fact. So that standards on findings of fact allow judges to essentially determine questions of fact and therefore the legal outcome of a case based on their own view of what justice on a particular case requires. Same in respect of mixed questions of fact and law, which is subject to the same standard of review, the rigorous standard of review, unless you can extract a pure question of law. And I'll deal with pure questions of law when I deal with hard cases issue. And another example of incredibly unconstrained findings of fact and law is in the context of administrative law, where, as you know, not only findings of fact, but findings of most legal questions is only subject to a reasonable standard, review standard, which obviously you may make a reasonable finding, but in our law, there's only one correct answer. The fact that we might not impose that standard on administrative tribunals, as they do in England, and we don't, doesn't mean that the administrative tribunal below has reached the correct legal answer. And it does, therefore allows these tribunals to impose their views of the law, not necessarily based on what is correct, but what they find reasonable, i.e. what their personal sense of justice dictates. So even in the case of what I'll call intentional uncertainty, where the law has adopted incredibly general standards, you see that there is really immense room for judges and administrative tribunals to ultimately decide cases based on what they think is the just result, which is not dictated by the law themselves, because, as I say, the legal standard, reasonableness, is so vague as to not contain any real normative value. Now, let me move to the third point, the hard cases point, where Justice Sharpe argues that even in those, even if the answer is not obvious, if you use the proper reasoning, you look at the proper tools and sources, and you expose your legal reasoning to the criticisms of academics or appellate courts, you should be ultimately able to reach an answer that is the just and presumably the correct answer. And in my respectful submission, the problem with this approach, if you have a really hard case, now you're dealing with uncertainty, not so much within the legal system, as I described, where the standards are so vague that they effectively allow the judge to find the facts or the decisions in accordance with his or her own personal values, but you're on the margins, where here the law itself doesn't answer those questions. But Justice Sharpe thinks that you can, by rigorous reasoning and so on, arrive at the correct answer. The problem with that, in my respectful submission, is that it assumes that you can actually devise a legal system which is so complete and comprehensive that it contains, if you look hard enough, all the answers to all the possible legal problems. And so if you just think of a set of rules, it assumes that if you look hard enough at all the precedents and all the writings, you'll find the one answer that law dictates. And in my respectful submission, there's nothing in human experience that suggests that humankind is so wise that it has been able to devise such a complete and comprehensive legal system. And if my statement is correct, it necessarily follows that at some point, the answers to a particular problem will have to be found somewhere outside the pure legal system. And there's only one place to go. And that's where the judge's personal sense of justice is, because there's no other way to ascertain what the collective view of justice is. That's what the laws were supposed to do, but you've decided that it's not clear there. And it couldn't be otherwise, because there is no such thing as a complete set of rules or comprehensive set of rules. So I say Justice Sharpe's aspiration is laudable, that to find the right answer within a legal system if one looks hard enough, but it's impossible to realize. Science doesn't have all the answers, logic doesn't have all the answers, and there's no other way but to look at one's own personal values. And I say, and we can debate that later, if you look at Justice Sharpe's decision in the case of Jones v. Sigg, where he invented the tort of intrusion upon seclusion to give a remedy in respect of a violation of privacy, I say that it's clear that here his own approach, his own values, he says in the case that this case cries for a remedy, and as a common law judge, he's entitled to provide one. But in that point, the fact that common law judges create law doesn't in any way eliminate the fact that, as I said before, justice informs law. It precedes law. And if you don't have an answer within the law, you have to look at your own sense of justice. and another judge may well have decided that case differently. And it's not surprising, it's not a criticism, it's just the reality of epistemologically, a legal system cannot conceptually or logically contain all the answers. And if that's right, then you have to look outside. So let me conclude very briefly by referring back to Justice Sharpe's criticism of Chief Justice Roberts' analogy to calling balls and strike. I find that his criticism a bit surprising because any casual watcher of baseball knows that umpires have their own strike zones and their own sense of justice. Is the ball just in or the ball just out? It will depend on the umpire, as any pitcher or batter will tell you, just as any barrister, as first question whenever they take a case to court will ask who is the panel, who is the trial judge, and even former judges advising barristers how to argue cases will ask the same question. And we don't have, unlike in baseball now, objective video review. All we have are appellate courts, which do their best, but they are also, when faced with tough legal questions, faced with the same very problem that the legal system cannot be assumed to contain all the answers. And ultimately, it comes down to their own sense of justice. Now, I'll just say in conclusion that normally, like any barrister, I like to win every argument I present. But in this case, I'd be quite content to be proved wrong and allow judges like Justice Sharpe and Feldman to decide any case according to their own sense of justice, but only if the sentence meted out on me for being the loser is so much more merciful than that which was visited upon poor old Charles Cook. And I hope this concession will bring your mercy to bear.
All right, well, maybe I could just be allowed a brief response to that. Justice Feldman described Guy as one of our most outstanding counsel, and those of you who have listened in will know why from that very compelling performance. I always found when I had outstanding counsel in front of me that it was a good idea to not make a quick decision, but sit back and think about it a little bit. And I invite you all, just think about the implications of what he said a little bit before you buy into his persuasive case that he's presented. I agree that there's a distinction between law and justice, but I would argue that law aspires to achieve justice, and in fact, law embodies a justice content. It contains a certain view of justice, so that there is a distinction between law and justice, but there is an overlap as well. And what I aspired to do as a judge, and I think what most judges aspire to do, is they aspire to deliver justice under the law. Not just justice in the abstract, justice under the law. So there's this marriage between where law and justice intersect. That, I think, feeds into this notion of what is a judge's personal sense of justice. You know, judges and lawyers have been at the game for quite a while. Their sense of justice has been shaped by their legal experience. Their sense of what is right and wrong is not just a raw sentiment. It's based upon years of experience, years of working through cases and sorting out cases. Now, I'm not saying that judges are priests with divine answers. They don't, not at all. But they are imbued with the law's values, and the law, as I said at the beginning, in turn, it does embrace certain justice values. When it comes to hard cases, I have never claimed that I could with confidence say that my judgment was the right answer. All I claim is that that's what I'm trying to do. And I think that's the whole design of our legal system. I think every judge knows that they might be right, they might be wrong. That you'd have to be devoid of all sense of modesty not to accept that. But you, at the same time, you say, but I'm doing my best to deliver a judgment that is defensible within the framework of our legal system. I respect the parameters of our legal system. I look to the fundamental principles of justice that the law embodies and that structure our legal system. And I do my best to decide the case according to those legal principles. Am I right? I don't know. There's no way I can know. But that's the way we structure our, if you like, our aspiration. We are aspiring to achieve justice. So it's a kind of a system-wide attempt that over time we will gradually achieve justice. We probably never will, but that's what we're aspiring to do. So I never claimed that my judgment that Guy referred to in Jones and Sig was the only way that case could be presented. But what I tried to do in the judgment was to show that there were so many different elements in our legal system, in the legal rules that we had created, that pointed in the direction of recognizing the right to sue for invasion of privacy, intrusion on seclusion, that seemed to me to be the right answer. Others are free to disagree. In terms of standard of review, I think, to me, the answer to that is simply this. Why do we have a standard of review that precludes appellate courts from interfering with factual findings of trial judges? Because we think that trial judges are in a better position to make the best decision. Same with administrative tribunals. They have the expertise, the background in that area. So appellate courts hands off. It's not that we are yielding to the fact that it's hopeless to ever get to the right answer. It's that we think that the trial judge on factual findings and the administrative tribunal in administrative law are more likely to get the right result. And in terms of constraint, I have to tell you that I'd be interested if Justice Feldman shares this view. I found that the standard of review very, very often precluded me from imposing my personal views as to the correct result in the case. I might say I would never have found the fact that trial judge found, but I can't say that it was so obviously wrong that it's up to an appellate court to interfere. I never would have imposed that sentence. It's either too light or too strong, but the trial judge was there. He or she had the advantage, all the advantages of being there on the scene, and I have to leave it up to them. So that was a clear constraint on my ability to decide a case according to my personal sense of justice. So there's a few brief points for you to reflect on. I think Guy should be entitled to a surrebuttal or whatever point we're at in this exercise.
Well, just quickly, then very quickly, taking the last point, the standard of review. My point is not at all that the appellate judges might not at some point resist the temptation to intervene, although recent cases in the Supreme Court suggest there may be different views as to how flexible that standard is. But my main point was quite different, is that the trial judge's assessment of what's reasonable, for example, just to take that example, is necessarily based on his or her own private view of what justice requires. Because once you've said, well, did the doctor act reasonably or not? What does that mean? Different judges will have different views. And those views will be based on exactly the same evidence, the same law, and the Court of Appeal may or may decide not to intervene. But it doesn't deal with the point that the initial assessment is ultimately not dictated by the law, because the normative direction or value of reasonable is extraordinarily limited. And therefore, what else do you look at? You look at your personal experience. On the other point about hard cases, obviously, I agree with Justice Sharpe that there is law and the court must look at that. But what he doesn't answer is that conceptually, there is a limit as to how much the body of legal rules, if you look at it as if it's a bag of rules, there's a limit as to how much it can tell you. That's why they're hard cases. And at some point, you may have a personal, I say that the determinative factor is your personal belief. You may, as I think a fair reader of the case Jones and Sig, he said, well, okay, he reconciled his view that this case cried for justice with, well, we have privacy in the charter, and there are a number of cases which haven't ruled the cases. There were motions to strike that they were not struck because the right might exist at some point. But the same rationale or a different rationale where a judge might have said, that's the job of the legislature. Another judge may have said, well, even yes, there's a remedy, but it's not my job to do it. Justice Sharpe explicitly rejects that, although he doesn't quite explain why. But I say in that case, a judge could have said, yes, there is a remedy, but it's not my job to do it. And ultimately, then, when you think about this, it cannot be any other way. It cannot be any other way that the instinct of a judge, however informed it may be by experience, is ultimately a personal view where the rules as they exist are simply not complete and comprehensive, and the principles either. To throw that everything in, it cannot suffice. And it's no criticism to say the judge had to resort to his innate sense or developed sense of justice. It can't be otherwise. And we're lucky in this country to have judges who do not go off and make decisions that are clearly illegal most of the time. But it seems to me that we have to acknowledge, at least that's what my mandate is in this debate, to argue the proposition that personal views cannot but have an influence and be determinative, both in these cases, which I call intentional uncertainty, where the law adopts very general standards, or where there's accidental uncertainty, where the law didn't design the uncertainty, but because of its complexity or otherwise, there's just not a clear answer.
So I am going to jump in at this point, and there are a few questions that have come in. Sorry, start my video. Yeah, there are a few questions that have come in, but I just want to pick up right where Guy left off just to start. And that is with the role of AI. So, you know, AI now says that you can predict the result in any case by just feeding in to the computer all the cases that are relevant on the subject. And I don't know if Professor Allery is watching, but I certainly think he would say that. And that so this whole idea that somehow the personal sense of justice making a difference is just obsolete. What do you say to that, Guy?
Well, I haven't used that. I wouldn't think it at all contradicts what I'm saying, because if it takes into account who the judges are, in some cases, you might be able to predict that, but not because they don't have a personal sense of justice that's featured in the cases that are reviewed. I don't think it tells you one way or the other. The fact that you can predict the outcome of a case by looking at the jurisprudence does not mean that it is that these previous cases were the result of the application of the law technically. It could be other factors. It just means you can predict. That's all it means.
So we have some great questions coming in here, and I'll just jump in and grab a few of them. So one of them is that cases come out from all the courts, particularly the Supreme Court of Canada, and particularly on ones that touch people's personal views or personal lives. The media jumps on it and the public jumps on and maybe agrees or disagrees, and there can be some significant criticism. So Justice Sharpe, do the judges take into account at all how the media or the public is going to react to a particular decision?
Oh, I think the answer to that is yes. I think that it's a public function that a judge exercises. And I think that the judge is responsible to the public for the duty to decide the case. And I think that the judge wants to do his or her best to explain the decision so that the public can understand it. So I think that one always would be looking at how this is going to come across. On the other hand, I think that if a judge simply thinks that he or she can cater to public opinion, decide the case in a way the wind is blowing, the current wind is blowing, I think that judge is in for a pretty rude awakening, because I don't think that's what the public expects judges to do. So I think that consciousness of current social conditions, current social attitudes is important in judging, but ultimately the judge is a judge, and the judge is there to take a sober look at the case in terms of the applicable legal principles, and be prepared, have the courage to make unpopular decisions, because that's where the whole credibility of the judicial process depends on. So I think the judge is thinking about what the public is going to think, but not in the narrow sense that I've just got to make a popular decision.
Do you want to add anything on that from counsel's view?
Well, only to say that I think as counsel, we are aware that judges may be, and increasingly there are effectively campaigns to intimidate judges before, or to try to create a narrative in the public that is presumably designed to try to influence the court one way or the other. I mean, I've been in many cases where it was evident that is what was happening. But I have no doubt in my mind that these are futile. Maybe there are some rogue judges here, but in my experience and conversation with judges, they are quite aware of what's happening, and they do try to apply the law as it is, regardless of how popular the decisions are. And there are decisions that come out that are incredibly unpopular, and the judges presumably knew that they were going to be so unpopular, and they made them anyway. Nonetheless, it seems to me that one of the things we should be most proud of is that we see that happen time and time again, that courts have made decisions that clearly would not be particularly popular with some segments of society. And it's a testimony to the fact that judges are trying to do their best to do what they think is just, even if it's not completely based on the law.
We've just added a little tail in on that one.
Well, my brief is for an hour, you see, so I have to do this for an hour.
I mean, really, it would be more because it is the law, even if it is unpopular, rather than the opposite, I would suggest. But anyway, I've got another question here. Please say more about the role of precedent, which influences the scope of a law almost as much as statute. When is precedent sacred and when is it malleable? Bob?
Well, that's hard to answer in a very short space of time. I think what we've seen in recent years is that there is a greater willingness, especially on the part of the Supreme Court, but even on the part of our court, my former court, the Court of Appeal, there is a willingness to rethink some precedents. And there's some decisions that lay out the principles that should guide that. But essentially, it's when a decision has been made on certain facts or in a certain social context that no longer applies, that a court can take a look at that case and overrule it. It's not done every day. It's not done too easily, but it can happen. So I think we're seeing a sort of a more sensible approach to precedent in modern times, where precedent is respected, but there's a willingness to say, look, that case was decided at this time in this context, that no longer applies, and we should take another look at it. Also, there are times when the court will say that just was an incorrect decision. That takes a lot to get a court to say that, but it certainly has happened. And the idea behind precedent is to foster certainty in the law. If you have a decision that was wrong, it tends to create a lot of problems, as judges will see what they can do to distinguish it or get around it. And so sometimes it's better, in the name of certainty, just to overrule it and start afresh. But that's a pretty complicated question, the whole question of precedent.
All right, I've got another one that I think is very important for today, and that is this. The reasonable person in today's society, is it viewed differently when we have so many cultural and religious and other identities that are very important now in our community. Do those cultural differences and other differences mean that maybe the reasonable person standard is going to be more difficult to discern and apply?
Well, I see Justice Sharpe thinking hard on this. I would say that to me, the answer to that is obviously yes, because I mean, in civil law, the standard of the reasonable, that used to be in common law, reasonable man, now we say reasonable person. In civil law, used to be le bon père de famille, which in and of itself, the good father, evinces a whole value scheme about how you would judge conduct. You know, le bon père de famille, not the mother, but the father. And so these standards, even as we articulated them, have evolved to be more neutral, to recognize an evolution in society. And I think the question simply underscores that these standards are inevitably flexible and have to be in order to take into account these developments and will create challenges, it seems to me, for both advocates and judges to decide in a particular case what the reasonable person would have done if one refers to a society, a multiracial and multicultural society. There isn't anymore a social standard which people say, well, that's one, and now we have probably many. And I suppose Justice Sharpe maybe has had cases where that issue was raised, but I would have thought that it's difficult to now assume that a reasonable person standard is one that is solely determined by one cultural set of values. It's kind of difficult to argue that, it seems to me.
But could I throw this out, that wasn't that always true, that it was a bit of a myth to think that there was one reasonable person or one reasonable man, that really it was ever thus, that different people have different standards, and therefore the reasonable person was always something that was a judicial invention made to apply a standard that was going to be reasonable and acceptable.
You're making my case better than I've made it, because I mean, I basically said that I think that's true, that there was never one standard, but I do think that today it's even more complicated, because you just can't look at a society and just say here's one or two or three reasonable. It's composed of so many distinct cultural approaches to what reasonable action should be, that I can't imagine the court wouldn't have to take that into account when applying it to a set of facts. But I'm not a judge, so I'll turn it over to the judge, who's being strangely quiet on this question.
No, I mean, I agree that in setting the reasonable person standard, you have to look at your society, and our society is a very diverse society, and you have to take all of that into account. What I would say, though, is that ultimately, everyone's subject to the law, and everyone, for any given situation, there will be a reasonable person standard that everyone will have to follow. That standard may be formulated in light of the diversity of our society, but there isn't one reasonable person standard for this person and another one for that person. Ultimately, it's shaped by the diversity, but it then applies to all.
A couple of personal inquiries have come in, so I'll just ask one of them right now, Justice Sharpe. What inspired you to want to become a judge?
Well, a lot of things, but I think if I had to pick one thing, it would be working at the Supreme Court with Chief Justice Brian Dickson as executive legal officer. He was, in my view, the very model of a great judge, and you couldn't help but be inspired by his example. And I learned a great deal from him. I learned a great deal from a lot of other people too. But if I had to pick one thing, I would say the experience of working with Brian Dickson was the thing that influenced me mostly.
A couple of people have asked about comparative law and whether or not our courts are are doing enough to take into account the laws of other jurisdictions that we respect. Justice Sharpe?
Well, I can start on that. I think the answer is probably that we're not. One of the reasons I think for this is that, at least in the Court of Appeal, we rarely got any argument on that. And we tried to stick to what, base our decisions on what we'd heard. It was very rare for counsel to raise in comparative law points. But I think that, especially in terms of my idea of this aspiration to just correct results, evolving over time, this collective enterprise that we're engaged in, I think that any help we can get from comparative sources should be most welcome. And I was never quite clear why we didn't get more of it in argument.
If I might, Justice
Yes.
Feldman, I, as you know, practice in both Quebec and Ontario, and have been called to the Quebec bar for 20 plus years, and in Ontario for 40 years. I'm astounded, actually, that we, in both systems, rely so little or looks so few times to the other system, because that's my reflex, certainly since I started to practice Quebec law, has always been to look outside the common law or vice versa. And there's very little happening, and yet it can be immensely instructive. And I mean, the Supreme Court obviously is mandated in a way to make comparisons, and those are helpful. So I think there's fertile ground. I'm flabbergasted, for example, when people argue even medical negligence cases, they won't look at Quebec cases, and vice versa. They look at injunctions law, and they'll look at Quebec cases. They won't look at the rest of Canada or England, for that matter. And it can be immensely fertile. So whether or not it's in aid of Justice Sharpe's aspiration or just in trying to influence the courts one way or the other, I think we are underusing the richness of our dual legal system in this country.
All right, a little switch again. A couple of people have asked about racial biases embedded in the law. How do judges deal with that problem when it arises in a case?
Well, I think obviously that's something that you want to eradicate from the law. I mean, in certain steps have been taken, but hugely farther to go on that. Both Justice Feldman and I were trial judges and sat with juries and saw the vetting that goes on concerning racial bias. And I always thought that was actually a very positive development in our law, that we would now force potential jurors to confront the fact that they were dealing with a racialized accused, and to state that they would not let that interfere with their decision. So we have taken some steps, but obviously, the law is a reflection of society, and historically, our society had obviously racist views, and those got embedded in the law. And to the extent we can identify and deal with those, we should.
Thank you. I'm going to ask you another one, Justice Sharpe. Someone's asked, and I don't know if you can come up with this, but you may have thought about this a lot. What was the hardest decision you ever had to make? Hardest case you ever had to decide?
I've asked that question, or what was my favorite case, whatever. In a way, I didn't have a favorite case, or every case is hard in a sense. I mean, it's not hard in the sense that Guy and I were discussing it, but every case is hard if you're a judge, because you can't help but feel the weight of the responsibility of making a proper decision when you have those litigants in front of you. So I sort of resist thinking about what was the hardest case. I suppose if I looked honestly at that question, I'd come up with a case that I got wrong, because that obviously was too hard for me to get right. But I've sort of put those out of my head.
Someone's asking, they've started with the premise that I'm not sure is really a premise that the panel has really embraced, but if a judge is prohibited from applying their own life experience and values in a search for a just result, should we continue to seek diversity in appointments to the bench? What is the purpose of seeking diversity in appointments? As I say, I'm not sure the premise is right. I think Guy has argued that personal life experience is extremely important. And I don't think, frankly, anyone would disagree with that. But to take that on, what is the purpose of, I think it's important to say it. What is the purpose of diversity?
Well, I think my own view is diversity is important in judicial appointments for several reasons. One, I think that given the makeup of our society, we don't want people coming before the courts and looking up there and seeing three old white guys like me. I mean, that's just not going to inspire confidence. So I think to inspire confidence in the justice system, the bench has to reflect the community. I think the other thing is, if we're only selecting old white guys like me, there's got to be something wrong with that selection process. That I think if you aren't getting the people that represent the diversity of your society, you better look at the process and make sure that it is open and fair. So I think that's very important, and I think it's it's really just a question of confidence in the justice system. If it doesn't reflect, if the bench doesn't reflect the society at large that we have, then the administration of justice will suffer. It won't be as credible. So I think it's very important.
Can I just add, Justice Feldman, that maybe a compliment to that I mean, you can't have a diverse bench unless you have a very diverse bar to begin with. And I argued for the Law Society the Trinity Western case, which really had to do with making sure that the bar in Ontario did not sanction or approve any discriminatory admission policies, because ultimately, not only would it be, from the point of view of the Law Society, a moral wrong to do so, but it would lead to a much more competent bar from which you can choose judges, to have a diverse bar, whether or not it's based on social, sexual orientation or religions or so on. So not only do we want, I think, a diverse bench, we want a diverse bar, and make sure that any barriers to achieving the most diverse bar possible are removed. So you can't have one without the other, I guess, is what I'm trying. And so we have to continue efforts both for diversity on the bench, but also diversity at the bar, which enriches, I think, the bar and also makes the bar much more useful to the litigants ultimately, and the courts.
So we're coming near the end, and I have a couple of questions that are a little bit different, and I think I'll go for them, and we'll see if we have time. So one of them is, are the characteristics of a good judicial decision the same or different than the characteristics of a good arbitration award or an adjudicative determination? Since you both have experience in both now, arbitration and judicial decision-making. Justice Sharpe?
Yeah, I think the same applies. I mean, arbitration as opposed to mediation, arbitration is really an alternative to a judicial decision. And I think the parties expect a decision, a judicial type decision based on the applicable legal principles. So I would say that arbitration is very similar, if not identical. The idea of a good award would be the same as a good judgment.
All right, I'm going to squeeze in one more question. What is the role of Indigenous legal perspectives in looking for the just legal answer in hard cases, even if the issue does not directly implicate what might be considered an Indigenous case. So does Indigenous law play a role in other cases?
I see Guy muted himself or turned off the mute and then turned it back on. So I'll do my best to answer that. I mean, I think there's a growing recognition that Indigenous law is an important part of the Canadian legal landscape, legal experience. And just as Guy has quite persuasively argued that common lawyers and civil lawyers would benefit from each other, learning about each other and understanding each other's system, I think there's no doubt that the European legal cultures have a lot to learn from the Indigenous tradition as well. So that is something that is emerging. And it's clear from the Supreme Court's decision, some of the Supreme Court's decisions, that they're sympathetic to Indigenous legal perspectives. So I think that is something that certainly can help improve our justice system.
Well, I agree with that, and I would just add that as Justice Sharpe says, that I think in the search for justice, if it's true that no single legal system can devise all the right answers to find all the just solutions, it makes sense to look to other legal systems, including Indigenous legal system, to assist us in that search. And it may be that while it's outside the common law system, either the civil law or Indigenous legal norms will point us in the right direction, and we won't have to just rely on some non-judicial or non-legal values. And so the value of looking at other systems' approach, including obviously particularly for Canada, and Indigenous systems and principles, is self-evident, it seems to me. It just assists us if our own system doesn't give all the answers, or we're not sure it gives the right answers, to look at how others have approached the same problems. And it seems to me our view of justice can only be enriched if it's informed by more than our own legal tradition. It's a bit presumptuous to think we've devised all the right rules for all the situations for all people. And that's what, in my view, justifies the courts looking as far abroad in the field as they can. And in our case, we don't have to look very far. We're going to just look to Indigenous law and civil law. It's all within the same country. So we should make a greater effort to look at those sources before we decide hard cases, it seems to me.
Well, it's hard to end this. I think it's a very interesting place to end. It is hard to end. We've got a lot more questions that could have been asked, and I think it's been a fascinating discussion. And maybe it'll be continued and again reprised and continued, because there's a lot more to say. Thank you both very, very much, and thank you all the participants.